Hello, Bevan Warner from Victoria Legal Aid, and I won't be asking you a question about funding, but can I put the question this way? As Australia increasingly says no to family violence and policing responses continue to strengthen in this area, more and more families in acute stress are being surfaced into the court system. The Commonwealth Government has responsibility for federal family law courts, but not the policing responses to family violence or the state courts that enact the first crisis response for families, usually in the form of exclusion and violence restraining orders. What are your government's priorities in this area, and do you see a future for a unified family court system in Australia to overcome the practical gaps and failures of the present overlapping systems?
Well, Bevan, thank you for that. It's a very important issue. It's an issue that I've discussed with Professor Helen Rhodes, the Chair of the Family Law Council, and coincidentally, it's an issue that I discussed as recently this morning with Justice Michelle May, the President of the Australian Institute of Judicial Administration. There is no doubt at all that there are matters of overlap between the family law system and obviously administered by two Commonwealth courts, and matters which arise from essentially the same or related factual situations, domestic situations, that are largely the province of the state courts. You talk about violence, but there is also another very important issue, and that is children's matters. As the family law practitioners in the room will know, children's matters are by category the largest number of matters dealt with under federal family law by the Family Court and the Federal Circuit Court. Yet many of the issues that give rise to the needs of children finding themselves in the family law system are also issues that arise in state courts with jurisdiction over children and guardianship. So plainly, there is a need for, in both matters of violence, domestic violence, and in matters concerning children, and in matters where both of those issues arise, as they commonly do, plainly there is a need for the jurisdictional boundaries to more truly reflect the needs, both from the point of view of disposing of all the issues in one set of hearings in one court, rather than in two sets of hearings in different courts. And that is something the government does have under review, yes.
Senator Alan Atwood from the Big Issue magazine. I sense a deep-seated and pervasive disillusionment with politics and politicians from all parties. I think people are tired of the repetition of banal slogans, policy driven by polls, and just general lack of civility. Do you also sense this, and is there a solution to it?
Well, if I were Tony Jones, I'd say I'll take that as a comment, but I don't have the luxury of being Tony Jones, so I'll let me respond. I think I've been involved in politics in one way or another all my adult life, and there is never a time when I haven't heard people say politics these days is more tawdry or less inspiring than it used to be. Now, I think we've been through a pretty difficult time in Australia in the last 6 years, particularly in the last parliament when you had a hung parliament. But cast your mind back to, for example, the era of Whitlam, which some in this room will remember. I'm not sure that the politics in those days was any less intense or indeed bitter than it is today. The parliamentary system exposes human nature at its best and worst, and the media are only interested in the worst, so you kind of get a slightly exaggerated view. But I don't believe that that politics is the poorer today by comparison with previous times that I can remember. So I don't accept your premise. And let us judge by this metric: the quality of the people who want to come into Parliament. Now, I see among my colleagues, I don't know the new Labor Party members particularly well, but I see among my colleagues some of the very best people in the country within their age group. I see in people like Josh Frydenberg and Christian Porter from Western Australia, and Alan Tudge, for example, another Victorian, and someone who's just come into Parliament, a man called Andrew Nikolic, the member for Bass in Tasmania, who was, among other things, the commander of the Australian military forces in Iraq and then went on to be the Deputy Secretary of the Defence Department in charge of international policy. I see people of really great quality and idealism. Now, the system does grind you down because it's an adversarial system. Not everybody is always at their best, because that's human nature. But I am inspired by the quality of people who do want to have political careers, and I am remorselessly, relentlessly optimistic about the capacity of the system in its own untidy, ungainly, sometimes undignified way to come to grips with the nation's challenges.
Rainer Tang, Immediate Past President of the Law Institute. I'm also a tax lawyer, so I'm kind of interested in the new federalism. If you're passing more responsibility back to the states, then states also need the funding to be able to achieve those programs. And I believe the Commission of Audit had suggested that income tax powers be passed back, or some part of income tax powers be passed to the states, and I wondered whether you had a view on that part of it and how it might fit with red tape reduction strategies of the government.
Well, I'm not going to express a view on that, because if I did, that would be unpardonably arrogant of me to trespass upon the responsibilities of my colleagues, Mr Hockey and Senator Cormann. But certainly red tape reduction, if I can just fix on the last bit of your question, is very much a priority of our government. And you're probably aware that I think it was in April of this year, we had our first repeal day, and we repealed about 8,000 acts or legislative instruments. Most of them were subordinate legislation, but we repealed about 8,000 pieces of legislation. And that only took us up to 1971. We're going to have another repeal day later this year. And I'm not sure that that's going to bring us up to 2014. I think there might have to be a third tranche next year. But, you know, one of the problems with government is governments do rest content to leave things lie on the statute book. And unless there's pressure for reform, they just stay there for good. One Act of Parliament that was recently repealed, you might be interested to know, was the Act giving effect domestically within Australia to the provisions of the Treaty of Versailles. That had lain on the statute book until a year or so ago. So red tape reduction is a very important priority of the government. In our relations with the states, red tape reduction is one of our core objectives, and an absolutely central part of red tape reduction is the repeal of redundant or unnecessarily invasive legislation.
Senator Brandis, thank you for joining us for lunch today, and for the President for putting on this lunch. It does me well to be able to share the conversation with you, so thank you for the opportunity. I'm a practitioner. My name's Helen McGowan from Albury-Wodonga, and there are two things I have to ask. One, would you consider coming to Albury-Wodonga and being a guest of our profession, and maybe having another conversation with us, particularly in this idea of the new federalism, in my particular interest in how the private and the public profession work together to achieve justice for community. So that's just an invitation. We can talk about that later. But the main thrust of my interest is in your commitment to frontline legal services. In New South Wales, we have a system called regional justice planning, where the private lawyers work with the public lawyers to work out what are the systemic issues that need addressing in law reform and public advocacy. And in Victoria, we have legal assistance forums that do the same. If my particular interest is in how, under the new regime, you see the new federalism, my fear is that we will devolve responsibility for justice planning to the states and lack that holistic planning around justice. Can you explain to me your vision for addressing systemic issues that we have as an Australian society, perhaps even as Team Australia? How do we address these issues at a broader level than beyond the local?
Well, thank you very much. That's a very thoughtful question, if I may say so. As to visiting Albury-Wodonga, I do try to get around the profession. I mean, I have visited a lot of regional centres in the years since I've been the Shadow Attorney General and now the Attorney General, so I'll write me a letter and we'll try and fit it into the program sometime. On the larger question you ask, of course the whole point of the speech I've just given and the whole point of the Prime Minister's Reform of the Federation White Paper is to recognise that there is a larger role for the states and a smaller role for the Commonwealth. A larger role for the states and a smaller role for the Commonwealth. Now, and that's what the High Court has ordained, indeed, in Pape and Williams. Now, as to how that broad philosophical objective takes shape in any particular area of policy, that obviously has to be dealt with on a case-by-case basis. And no decisions have been made specifically in relation to the provision of frontline legal services. But I want to assure you that I do see into the future a significant role for Commonwealth leadership in this sphere.
Good afternoon, Senator. Ned Roach from the Legal Services Board. A lighter question. What do you enjoy most and least of being both Attorney General and, more curiously for me, Minister for the Arts?
Well, that's a good question. I don't think there's anything I don't enjoy about it, as a matter of fact, because this is my dream job, and I'm very conscious as a legal practitioner myself who has either as a student or as a law clerk or as a judge's associate or as a barrister or as a senator or as the Attorney General been primarily concerned with the law since I was a first-year university student. So I'm extremely conscious of the honour of occupying this role. And there's nothing about it that I don't find satisfying. What I most enjoy, what I want to do is to ensure that the quality of the decision making is as good as it should be. You know, politics is a contestable space. People will have very passionate opposed views about a variety of things. I mean, one of my great causes is to remind people of the importance of pluralism, and that sort of informed the free speech debate. And people should respect each other's differences. But regardless of the outcome and whether you agree with the outcome of a decision or not, you should be able to be confident in the integrity of the decision-making process. And I do enjoy working with my department and with my staff, trying to reach the right decisions for the right reasons in an informed way. That I find intellectually very satisfying. You may not agree with the outcome, it's entirely a matter for you, but every citizen should, I think, have a minimum expectation that their senior public decision makers do bring a certain intelligence and integrity to the decision-making process.
Hi, I'm not a lawyer, I'm just here as a guest, but my question is about the Constitution.
Yes.
Does it have any influence in the way the government negotiates with foreign countries? Obviously, we negotiate with America and they want to influence our laws. Does the Constitution have any control or guidance, or does it affect in any way how those negotiations take place or the results of the negotiations?
Well, not directly. I mean, obviously, any treaty Australia makes with a foreign state has to be consistent with Australian law, and that means the implementation of the treaty has to be consistent with Australian law. It's where the issue arises in particular is at the implementation stage, because particularly take the free trade agreement that the Howard government achieved with the United States, or the free trade agreements that my colleague Andrew Robb has achieved now with South Korea and Japan, and is seeking to conclude with China. They all have implementation requirements so that the two states party undertake to give effect by domestic law to the provisions of the treaties, and that sometimes does raise constitutional issues. And those free trade treaties, or trade treaties generally, tend to have a federalism clause which acknowledges the limitations of the central power, because obviously they're negotiating with the central government, not with state governments, and the central government represents itself. It doesn't act as it were as agent of the state governments in those negotiations. So at the implementation stage, that can potentially raise legal issues of which negotiators and senior officials and ministers are conscious.
Hello, my name's Catherine Navarre and I work at V-Line. I'm a lawyer with V-Line. So in typical Q&A style, I have my question pre-written. Senior government ministers have made statements such as the role of the government is not to ensure equality, and the impacts of high uni fees will not impact on women because they don't study law. As the first legal officer, what are your thoughts about how these policies will affect the future generation of women lawyers, women and the greater society?
Well, I don't recognise the quotes that you've attributed to members of the government, and I'm not going to trespass into the field of another of my colleagues, Mr. Pine, in relation to the university fee issue. But our government is committed to equality of opportunity. It is committed to gender equality. One of the main reasons that the Prime Minister is so keen of the paid parental leave scheme, which has attracted a lot of criticism for some, is to recognise that if women want to have a family, that as much as society can afford to do so, that ought not to stand in the way of their careers. And paid parental leave ought to be a workplace entitlement, not a welfare entitlement. And I think the Prime Minister's strong advocacy of that is a token of his good faith on this issue. In terms of my own role, let me give you an example: judicial appointments. It was during the Howard government that the number of women on the High Court increased to 3 out of 7 as a result of decisions that Philip Ruddock made. I've appointed 2 judges so far. The first was a woman, the second was a man. So, I'm the father of a daughter who's studying to be a surgeon. So you got me at hello when you raised the issue of commitment to gender equity.